Good afternoon, ladies and gentlemen, and welcome to Phil Fisher's webinar on how to leverage DPIAs for AI risk assessments. My name is Leonie Power. I'm a partner in the tech and data team at Phil Fisher, based out of London. I'm joined today by my fellow partner, Diego Rigatti, who is a partner in the tech and data team in our Phil Fisher Italy offices, and also by Nuria Pastor, who is a director in the tech and data team based out of our London offices. Today's webinar forms part of a series of AI webinars that we've been running. Part one took place throughout January, February, March, and April. You'll see details of that there. For anyone who'd like to listen to part one, please head to our privacy YouTube channel and view our AI playlist. The details of that are at the end of this presentation. We also conducted part two, which comprised 3 webinars. Again, these are all available on our YouTube channel. And this webinar forms part of part 3. Well, in fact, actually, it still forms part of part 2. Part 3 has yet to launch. I'm getting ahead of myself there. But if you're on the team's mailing list, you'll receive an invite over the summer to join, or you can alternatively contact Phil Fisher to make inquiries, but you'll see details of those webinars on this slide. Okay, so what are we going to cover today? Well, we're going to look firstly at the intersection between the GDPR and the EU AI Act, because our focus largely is going to be on how we can leverage DPIAs in particular for AI risk assessments and how we can build atop some of the governance policies and procedures that we might already have in place from a privacy perspective in order to meet compliance obligations under the EU AI Act and indeed to ensure ethical AI implementation across the board. So we'll look at that intersection. We'll also talk a little bit about transparency and explainability, which are concepts that feature very largely within the EU AI Act, and obviously transparency is a key principle also of the GDPR. We'll talk specifically about AI assessments and what is required under the EU AI Act, and then we'll look at GDPR DPIAs and what needs to be considered when conducting a DPIA in respect of an AI system or model. And then we'll give you some practical key takeaways for implementing any kind of AI governance program, or basically approaching how you might start to govern AI systems within your business. Okay, so looking at the GDPR EU AI Act intersection, I wanted to really just set the scene a little bit here, because one of the things that is important to consider as part of any data protection impact assessment is the concept of fairness and also the concept of lawfulness, because that is a cornerstone principle of the GDPR. So fairness and lawfulness in the processing of personal data needs to be considered. And when we think about fairness, we really need to think about some of the ethical considerations that we see reflected across various principles and guidances that have been published in respect of AI. So we have, for example, the UK white paper on AI. We've got the recitals of the EU AI Act, which set out certain principles for ethical AI implementation. And we've got, for example, the OECD principles. We see a certain amount of commonality across all of those principles. For example, if we look at the UK white paper principles, they sets out 5 principles aimed at governing responsible AI innovation, and they include safety, security, and robustness, appropriate transparency and explainability, fairness, accountability and governance, contestability and redress. Similarly, under Recital 27 of the EU AI Act, there are certain principles set out in respect of trustworthy and ethical AI. And again, they talk about technical robustness and safety. They talk about transparency and fairness, non-discrimination. They talk about privacy and data governance and social and environmental well-being. And so across all of these various principles and guidances, and there are many, there's a certain commonality, and it's really for each organization to determine what principles are the best fit for its own organization. But when we think about fairness of data processing, then these principles of ethical AI will come into play. And that's, if you like, how you start to import some of the requirements of these principles when you're thinking about how you conduct a data protection impact assessment. Similarly, with the concept of lawfulness, lawfulness is not just about having a legal basis for processing your personal data. It's also about ensuring overall lawfulness, including compliance with applicable laws. And that could be the EU AI Act. And we should note in that regard that it has significant extraterritorial effect insofar as it will apply if the output of the AI system is used in the EU. But it could also mean other local legislation and related guidance. So it's about ensuring, as part of your DPIA in respect of any kind of AI data processing, that there is overall lawfulness, there is overall compliance with relevant applicable law, not just data protection laws. So against that background, let's have a look at the intersection between the EU AI Act and the GDPR. And it's worth actually mentioning in this context recital 10 of the EU AI Act, because that sets out that the Act does not seek to affect the application of existing union law governing the processing of personal data, including the tasks and powers of the independent supervisory authorities that are competent to monitor compliance with those instruments. So I mean, it's making clear that essentially, the two pieces of legislation sit in parallel, but we see from this slide that there is certain areas of intersection. So firstly, we know that the GDPR is aimed at protecting certain fundamental rights and freedoms, and that there's a focus on some key principles. And the rights that it seeks to protect are the right to privacy, the right to non-discrimination, and Article 5 sets out certain GDPR principles which form the cornerstone of the legislation. In a similar way, the EU AI Act is aimed at protection of certain fundamental rights and freedoms, including the right to privacy, non-discrimination, free expression, protection against harmful surveillance. And as I've mentioned already, there are certain principles set out in Recital 7, which again are set out in that slide, which talk about human agency and oversight, transparency, fairness, etc. The other key area of overlap between the GDPR and the EU AI Act relates to transparency. Under the GDPR, as we know, there are key transparency obligations in the context of data processing. So there's a need to be transparent when you're honoring data subject rights, when you're communicating, for example, in relation to data breaches, but also in relation to your data processing more general. And there's a requirement to provide certain statutory information, as we know, that's set out in Article 13 and 14 of the GDPR. Similarly, within the EU AI Act, there are many requirements in relation to transparency. There are some significant ones in the context of high-risk AI systems. There's lots of provisions around the technical information that needs to be provided. Then there are certain transparency obligations in relation to general purpose AI models and other information that has to be provided in that context. Other areas of overlap are in relation to risk assessments. So many of you will be familiar with the need, obviously, to carry out a data protection impact assessment in certain circumstances where there's likely to be high risk to the rights and freedoms of data subjects by virtue of the relevant data processing. There are potentially a whole myriad of assessments that need to be carried out also under the EU AI Act. In some cases, if there are high-risk AI systems, then there's requirements around conformity assessments to be carried out by the provider. In some circumstances, a fundamental rights impact assessment has to be carried out by the deployer of an AI system. And we'll talk in a little bit about these various actors and, on their roles. The other area of intersection is in relation to human oversight and accountability. Again, many of you will be familiar with Article 22 of the GDPR, which deals with automated decision-making or decision-making based solely on automated processing having a legal or similarly significant effect. And there are certain requirements in relation to that type of processing. In fact, there's a prohibition on that type of processing unless certain conditions are met. But one aspect is the need to ensure human intervention if an individual requires that human intervention. Similarly, there's requirements in the EU AI Act in relation to human oversight of high-risk AI systems. So again, we see, across this, the EU AI Act and the GDPR, many areas of intersection, which are going to be key considerations in the context of any data protection impact assessment that you are conducting. So I suppose when we think about AI and privacy governance generally, two key things that you need to do are to expand what you already have from a privacy governance perspective. So basically widening out your approach to DPIAs, etc., so that they cover any necessary new requirements under the EU AI Act to the extent that your system or model is caught by that act. But also ensuring that when you're carrying out a DPIA in respect of your data processing, that you address the specific AI challenges that are arising in a privacy context. And there will be specific challenges, for example, around accuracy, around ensuring fairness through non-discrimination, ensuring that there's no bias within the AI system, ensuring that you comply with the requirements of Article 22 of the Act in relation to automated decision making. So it's about making sure that you're, expanding out your DPIA to cover all of these additional requirements to the extent that they apply. Okay, I just wanted to briefly mention the roles under the EU AI Act and also under the GDPR. And there's a whole taxonomy of actors under the EU AI Act. There's this concept of a provider, which is essentially the person or the body that develops an AI system or a general purpose AI model, or has the AI system or general purpose AI model developed and places it on the market or puts it into service under its own name or trademark in the EU. A deployer is essentially the person or the body that's using an AI system. And then an authorized representative means natural or legal person that's located or established in the EU who's received and accepted a written mandate from a provider of an AI system or a provider of a general purpose AI model to perform and carry out on its behalf the relevant obligations under the Act. And then there's various other actors such as importers and distributors, which are given their own definition, and operators, is the term basically used to mean any of those actors that I've just mentioned. And then there's the concept of the affected person, which is, the person that's affected by the use of the AI system or the deployment of the AI system. So we have this taxonomy of actors, all with their own relevant obligations under the EU AI Act, depending on the AI system in question and the context in which the AI system is being implemented. So the other point to note then is you've got obviously the concept of controller under and processor under the GDPR, and it's important to note that there isn't necessarily a one-to-one correlation. It's not like the provider is always a processor, for example. Now, a provider of an AI system may well seek to position itself as a processor, but in some cases it may well be acting as a controller, or indeed a joint controller with the deployers of the AI system. And so that requires an assessment on a case-by-case basis. So again, as part of your DPIA, you would be working out, well, what role do I have under the EU AI Act to ensure lawfulness of any processing that I undertake and fairness of any processing that I undertake, and how does that relate to my role under the GDPR as a controller or as a processor, as the case may be. Okay, so looking then at the concepts of transparency and explainability, because this is another area of key intersection between the GDPR and the EU AI Act. Obviously, many of you will be familiar with the need to provide statutory information under the GDPR. That's typically done in the form of a privacy notice. So that's the means of providing the relevant transparency under the GDPR. Similarly, there's transparency obligations in the context of automated decision making, and it's incumbent on controllers to provide meaningful information about the logic that's involved in the relevant automated decision making and the significance and envisaged consequences of the automated decision making, and that's as set out in Article 13 of the GDPR. So that in particular would be relevant in the context of AI systems that are making automated decisions or making decisions based solely on automated processing that have a legal or similarly significant effect. There's also this concept of explainability, which is very closely allied to the concept of transparency. And it's worth noting in this context that the ICO, in conjunction with the Alan Turing Institute, have produced a very useful guidance on explaining decisions made with AI. So again, that will be a fundamental part of understanding what you need to do in the context of any AI system DPIA or AI model DPIA is how do you ensure transparency and explainability, which also goes to the overall point about whether you're engaging in fair and lawful processing. So that ICO and Alan Turing guidance sets out some different aspects of explainability. So it, for example, talks about the rational explanation, which are the reasons that led to a decision, and that rational explanation has to be delivered should be delivered in an accessible and non-technical way. There's the responsibility explanation, who is involved in the development and management and implementation of the AI system, and who can be contacted for a human review of the decision. There's the data explanation, what data has been used in a particular decision and how has it been used, what data has been used to train and test the AI model and how has it been used. There's the fairness explanation, the steps that have been taken across the design and implementation of the AI system to ensure that the decision that it takes or that it supports are generally unbiased and fair. And then you've got the safety and performance explanation, is the explanation about the steps that have been taken across the design and implementation to maximize accuracy and reliability and security and robustness. And finally, the impact explanation, the impact that the use of the AI system and its decisions has or may have on an individual and on wider society. So they are, key concepts within, when looking at any AI system. And so they would be key concepts in the context of any DPIA that you're carrying out that involve the processing of personal data as part of that AI system or AI model. And of course, don't forget other transparency requirements. So I've mentioned, the Alan Turing and ICO guidance. I've mentioned Article 13, but throughout the EU AI Act, in fact, there's a whole myriad of transparency requirements. Now, I'm not going to labor this slide in any huge amount of detail, but it just gives you an overview of the various touch points for transparency requirements within both the GDPR and the EU AI Act. So for example, you've got your privacy notice, the controller is responsible for that. Obviously, the relevant individuals or data subjects are the audience for that. The explainability statement, who's responsible for that might vary. It could be the controller, the provider, or the deployer, depending on the relevant context. The audience will be the individual user, or it might be other stakeholders, again, depending on the context as applicable. And there's various other requirements for example, the provider to provide certain instructions for use to the deployer, certain technical information to the deployer in order to ensure compliance with the EU AI Act. Various other requirements as well in relation to general purpose AI models, notifying individuals that they are interacting, for example, with an AI system so that they are aware of that. And so you'll see a link also to a blog that Nuri and I and one of our other colleagues, Matt, drafted in relation to transparency requirements under the Act and the GDPR. So on that note, I'm going to hand over to Nuria, who is going to talk a little bit more about the specific AI assessments that need to be carried out under the EU AI Act.
Thank you, Leonie, and good afternoon, everyone. So as Leonie says, I'll now look at AI assessments, and I'm going to start by looking at them and how they sit within your overall AI governance framework. So we can go on to the first slide, my next slide, please. Thank you. So AI assessments are only one of the elements of your AI compliance efforts, and they will not take place in a vacuum. They will take place in the context of a broader compliance framework. And in terms of the governance framework and your overall governance framework, there is no one size fits all. But on the left-hand side of the slide, I've set out some typical elements that are likely to feature in any such framework. So first of all, your AI governance framework will revolve around your organization's AI principles. You will have to define the principles that will be at the core of your AI governance framework and what is the overall mission or the objectives of your AI governance framework. There are a few things to consider in relation to your AI governance framework and the risk assessments that you will carry out. So I'll take each of these elements in turn. So you will need, first of all, to set out procedures in place in order to carry out these assessments and in order to assess risk of the new AI use cases that you are intending to roll out within your organization. You cannot carry out these risk assessments from the legal team and in a silo. Many stakeholders will have to be involved, including a higher body. For instance, you may call it the AI committee, who will ultimately be responsible to approve the use of certain AI tools within your organization. Your risk assessment will have to be designed so that it enables you to comply with your legal requirements. So you will need to develop tools to carry out these risk assessments. You also have to ensure that you are transparent, as Leonie just touched on. So how do you do this in practice? So your AI use case risk assessment procedure is likely to include actually more than one risk assessment. And we provide some examples of in the box on the right-hand side of the slide. So what risk assessments may you be carrying out? So for example, a gating risk assessment. This is an important one, and this will be an assessment that you use to categorize the risk based on your internal risk ratings. If you're subject to the EU AI Act, you can build in considerations to align to the Act, of course. So for example, prohibit such use cases which are prohibited under the Act. Even if you're not subject to the EU AI Act, you will have to have a tool in place in order to rate the risk of each AI use cases that you're planning to roll out. Another type of assessment that you may have in place is a fairness or ethics assessment. And this can be a separate tool to the other tools that I mentioned here, not least because if the AI system is not fair or is not ethical, it will be a no-go. So I refer back to what Leonie discussed earlier in relation to the values and the fundamental rights that that the AI Act and also the GDPR protect. The third type of risk assessment is a privacy and security risk assessment, so including DPIAs. And these are risk assessments to ensure that individuals' privacy is protected and that personal data is processed in a compliant way. And the final type of assessments that I wanted to mention are regulatory assessments, including those required under the EU AI Act, which I will cover in the next few slides. So as you can see, we have provided a few examples here on the slides in relation to the risk assessments that you may be required to carry out under the EU AI Act, including, for example, conformity assessments for high-risk processing or fundamental rights impact assessments as well for high-risk processing. So before I go ahead onto the next slide, we should remember that practically each of these risk assessments will require a tool. It doesn't need to be a very sophisticated tool. It may just be, for example, a Word document with the right questions there. But it does need to be fit for purpose. And there are risk assessments out there publicly available. So for example, regulators have issued some of these, including the ICO, which has published an AI risk toolkit. So you haven't had to look at these, by all means, do have a look at this because it is a useful tool to assess risk in an AI context. So let's go to the next slide, please. Thank you. So you will need to know the level of risk of your AI system in order to work out what assessment you are required to carry out. So under the EU AI Act, AI systems are classified according to risk, and there are 3 categories of risk. So you have prohibited systems, you have high risk, and you have low risk systems. In an earlier webinar in this series, we looked into these risk levels in detail. So here is just a quick reminder. So I'll take each of these in turn. In terms of prohibited AI systems, you simply can't do these things as a matter of EU policy because these AI systems are considered to infringe individuals' rights. So for example, AI systems which lead to cognitive behavioral manipulations to bypass free will, so for example, subliminal advertising, are prohibited under the Act. Another example of a prohibited AI system would be a system aimed at carrying out social scoring, so a classification of persons based on their social behavior, leading to detrimental or unfavorable treatment. Let's move on now to high risk, because this is an important area because it carries a lot of requirements. So high-risk AI systems are systems that cause significant risk to natural persons. This can be classified in 3 main buckets. So the first bucket is contains the products or safety components of products, and where EU legislation requires third-party conformity assessments. These focus on areas such as safety of humans, medical devices, and heavy industry, just to provide a few examples. In terms of the second bucket, this contains AI systems in a category listed in Annex 3 of the EU AI Act. And that's quite a long list, so I won't go through these in detail. But for example, these would be systems such as systems used for biometric categorization based on sensitive or protected characteristics, or systems relating to critical infrastructure, or other systems such as those which are used to admit individuals in the context of educational and vocational training. There is a derogation to the Annex 3 categories if the system does not pose a significant risk of harm to the health, safety, or fundamental rights of natural persons. If that's the case, a provider can document these, and on that basis, it can exclude the system from the Act's obligations on high-risk systems. So moving on to the third bucket, this applies if you conduct profiling on people with the data that you use for your AI systems in relation to your Annex 3 use cases. So this will also be high risk. So you won't be able to apply the derogation that I just explained if you carry out profiling. You will have to link this risk level assessment to your assessment of whether the processing of personal data you carry out will be high risk from a GDPR perspective and would therefore trigger the requirement to perform a DPIA under the GDPR. So high risk under the GDPR and the AI Act is not exactly the same, but they may overlap and they may be linked. So it's important to be aware of this. So what happens then if you decide to pursue a high-risk AI system? There are a number of further assessments and requirements depending on whether you are the provider or the deployer of the AI system. So let's have a look at the provider obligations and requirements. So if you're a provider of an AI system, here are some of the main areas you will need to address, including the following. And just to clarify, in relation to high-risk systems, as you can see on the slide. So you will need to ensure the high-risk system undergoes the relevant conformity assessment, which may be carried out internally or externally by a notified body. The purpose of the conformity assessment is to demonstrate compliance with the EU AI Act, and it's based on the assessment of the quality management system which developers are required to put in place in order to ensure such compliance. So moving on to the next point. So in terms of risk management and human oversight, there should be a risk management system put in place by the providers to monitor the AI system on an ongoing basis. The AI system must be developed in a way that can be overseen as well by a natural person. Another area that you will need to focus on is data governance and security. So the Act sets out requirements around the provision of technical documentation, record keeping, and transparency. And the transparency requirement is in relation to the information the developers provide to deployers. So moving on to the deployer requirements. So if you are a deployer, here are some of the things that you'll need to consider. So in certain circumstances, you will need to conduct what is known as a fundamental rights impact assessment. These are assessments of the system's impact in the specific context of use. This will only apply to certain type of deployers, for instance, those in the public sector. For all deployers, you will need to implement technical and organizational measures and data controls, assign human oversight, monitor use and risks, and keep logs, just to provide a few examples of additional requirements. Interestingly, the EU AI Act also sets out that deployers of high-risk AI systems should use the information provided by developers of the AI systems following the transparency requirements in order to, when they carry out their DPIAs. So this demonstrates another area of overlap between the AI Act documentation and the GDPR DPIAs. The last point on the deployer's obligations is that deployers who are employers are required to inform employee representatives and employees themselves before rolling out a high-risk AI system at the workplace. Again, this is an area of overlap between the rollout of an AI system under the AI Act and the GDPR, as the GDPR also requires that the relevant stakeholders are consulted when carrying out DPIAs, as Diego will touch on later. So let's move on to the next slide. So just to expand upon the point on how can an organization leverage their existing assessments, I have undertaken a comparison of a GDPR DPIA, a conformity assessment, and a fundamental right risk assessment. There's far too much detail in this slide for me to go through it now. So this is something that hopefully you can do in your own time. But just to summarize, we can see a number of common elements across each of the assessments. So for example, all of these assessments are triggered by activities deemed to be high risk by the respective regulations. Also, in terms of timings, these assessments all need to be completed before go live. So in practice, this means before the processing of personal data under the GDPR or before the AI system is made available under the AI Act. In terms of who is required to carry out the assessments, the organizations acting as the deployer or provided required to carry out each of the assessments may or may not also act as a GDPR controller who will be required to carry out the DPIA. But it's likely in practice that such overlap takes place in many instances. All of these assessments are tools to verify and document compliance with existing requirements. Each tool focuses on identifying and mitigating risks and then documenting these risks. So for example, under Article 27 of the AI Act, it requires that fundamental rights risk assessments include, similarly to a GDPR DPIA, a description of the risks of harm and the measures that will be put in place to address these risks. Similarly, also, some of the content in a DPIA will be covered in the technical documentation of a high-risk systems, which developers will have to take into account when carrying out the conformity assessment. So controllers who are also developers preparing such technical documentation will be able to leverage the information gathered. So let's move on to the next slide, please. Thank you. So before I hand over to Diego, who will look at AI system risk assessments through a DPIA lens, I just want to flag that there are other assessments under the EU AI Act that need to be considered. One such example includes general purpose AI models. This requires an understanding of whether or not the model imposes a systemic risk. Whether the AI model has systemic risk may be determined by a decision of the Commission, of the European Commission, ex officio, or following an alert by a scientific panel. Systemic risk may also take place if the AI model has high impact capabilities on the basis of the amount of computation used for its training. So just to conclude, as you can see, there is a lot of information here. So regardless of which of these risk assessments you are required to carry out, there'll be many areas of overlap in your EU AI Act compliance efforts and your GDPR compliance efforts. In practice, this means that organizations can build upon their existing processes, such as the DPIAs, in order to comply with the EU AI Act. So thank you for listening, and I'll now hand over to Diego.
Thank you very much, Nuria. Good afternoon, everybody. So I'm going to take care of the DPIA on an AI environment. We know that the fundamentals of any DPIA is based on the description of the processing activities, the assessment of the necessity and proportionality of the processing operations, an assessment on the risks to the rights of individuals, and then the measures envisaged to mitigate risks. But what if we are in an AI situation? So amongst the mandatory elements of DPI is a systematic description of your processing activities and purposes for processing. But to achieve these in an AI environment, you should include a description of the features and capabilities of the AI system that can be very peculiar to a specific and each and every AI system. The data flow diagrams, which should demonstrate in the relevance of personal data processing to your AI system at any point so decisions are made by automatic systems when, let's say, the AI system triggers in. Of course, the data, the underlying data, are always of paramount importance. So how many data subjects are involved, the source of data, if the data are internal to the company, are open source, are coming for web scraping. In this case, of course, also copyright issues can come into play, but this is not the theme of today's webinar. So the specific scenario is a DPIA on an AI tool has to take into consideration the different stages of the life cycle of an AI tool. It's not to be taken for granted that we are facing an AI tool in the final, let's say, deployable state, also can be in the development state. Quindi, the description of the way the process of data is carried out on the AI tool is made as is at the moment of such assessment, but in such a dynamic environment as an AI, especially if it's generative, or if it's in the beginning, in the training mode, these should be either periodically updated following the growth and changes of the data treatments performed by the AI, or already envisage its evolution, depending on the stage of development of the AI tool itself. Some tools then can also be GDPR more sensitive in a later stage when they use actual data, not anonymized, than at the beginning, or vice versa. So each and every time the assessment has to take into consideration these. After, next slide, please. after the description of the process, it's fundamental to check if processing is necessary before checking how to do it in a compliant way. If you follow these columns, the first question is can you achieve the same objective in a less privacy intrusive way? So the necessity analysis should start from comparing the data processing utilizing AI and a similar processing carried out with less automated and advanced tools. AI per se cannot justify its use. The DPI should capture then the objective of the new system, the advantages and the disadvantages of using it, as well as the availability of any potentially less intrusive ways to achieve the same objective. In the second column, we see that the question that we have to pose to ourselves is the AI tool proportionate? Interest versus risk to individual rights and guardrails to that. Proportionality part of your assessment should evaluate your interest against the risks to the rights and freedom of individuals. Transparency, and that was being mentioned already before by my colleagues, of the AI processing is a fundamental in a DPIA assessment on AI tool. The invasiveness or excess of it, the solidity, the security, the control the human still has over the AI when an intervention is possible, and if it's possible. And these can cause to prefer a non-AI solution. So talking about AI, also the respect of ethical principles might come into play, probably even more than when we're talking about the data protection, privacy issues. Remember that on the mind of the legislator in Europe, the safety and avoidance of risk for the individuals is of paramount importance. Any bias on accuracy on the algorithms may result in a detriment to individuals, and this possibility should form part of the proportionality assessment too. On the flip side, and we see the pink column now, if replacing manual process, decision document, human versus algorithmic accuracy, those are other things to be taken into account. Now, if the system will complement or replace human decision making, you might include a comparison of human versus algorithmic accuracy side by side to better justify the use of AI, for instance. And last column, you have to document the trade-offs. You have to balance and weigh them, between the statistical accuracy and the data minimization if this is needed. Next slide, please. Fairness. Fairness is something, of course, we always keep in mind when you are designing a privacy model, but at the same time is even more important in AI tools. From their design, fairness have to be taken into account. We do have to handle the personal data in such a way that is reasonably expectable by the people involved. It's fundamental to fairness in AI system that you don't process personal data that are misleading or unexpected. Talking again about the AI tool lifecycle, fairness must be found at each and any stage of such tool. And then there is the specific AI context. Ensure the system is sufficiently statistically correct and avoids discrimination. But when we're talking about discrimination, we're talking again about fairness, but it's a very broad and evolving concept itself. It might be very culturally dependent, while the training or the use of AI might involve multiple jurisdictions and their respective citizens. Fairness in AI differentiates itself from its GDPR cousin, being more related to the need to avoid bias and discrimination and ensure compliance with human rights. And then, compliance with other aspects of data protection law, data protection principle, supports fairness in general. So this has to be taken into account in the data protection by design default. Is mentioned the lawfulness, transparency, the purpose limitation, data minimization, security, accountability, and so on. And then there is the phase of the automatic decision making. Now, fairness asks also for the right to obtain a human intervention in case, express views and contest at the in scope of Article 22.1 GDPR. But then let's take a look at the impact on processing activities. It's a risk assessment. It's tautologic that you have to assess the risk of the harm to somebody. But your assessment must identify potential risks and divide them in different categories, because you should consider the so-called allocative harms, for example, related to the allocation of goods and opportunities among the group, and the representational harms, where the harm results from the subordination of groups along identity lines and lead, for instance, to stereotyping. The latter is particularly relevant to the training of AI systems and consideration relating to measures used to remove bias from data sets. All this process has to be documented. So next slide, please. We have to follow what can we call a risk scoring methodology. You should assign a score or level to each risk, measured against the likelihood and severity of the impact of individuals. We see a slide next to this one. You should remember the design and use of the AI systems may not just pose risk to individuals' information rights, but when considering sources of risk, you should consider the potential impact of other material and non-material damage of harm to individuals, like the one mentioned in the slide before. And we have to mitigate risk. The purpose of the risk assessment is this. So against each identified risk to individual's interest, you should consider options to reduce risk further. Example of this could be data minimization techniques or providing opportunities for individuals to opt out of the process. Once you have introduced measures to mitigate the risk you have identified, the PIA should document the residual levels of risks posed by the processing, the question. But then, last box, if residual risks are high, consult a data protection regulator. So remember that you are not required to eliminate every risk identified. This is against the basic rules and principles of risk assessment and internal audits. There is a balance between the costs to avoid or reduce risk to now to the risk itself, and a balance is accepted and required. Going to the next slide is just to show how the rating, the scoring can be pictured. And then we have to remember that there's also, next slide please, the possibility to call Article 35.9 of the GDPR into action. Where appropriate, the controller shall seek the views of data subjects or their representatives on the intended processing without prejudice to the protection of commercial or public interest or the security of processing operations. These sometimes is possible. It's easier to be performed when we are talking about a more static processing, as in an ordinary, say, GDPR scenario. But we're talking about AI. We're talking about something that could be disproportionate or practical. So with this last comment, I would give back the mic to Leonie, I think. Thank you.
Thank you very much, Diego. And with that, I'm going to wrap up with some key takeaways, a bit of an action plan. So if as a privacy professional or indeed a compliance professional, you've been tasked with looking or kicking off the AI governance framework within your organization or starting the process, then I think there's a couple of things that you'll need to bear in mind. The first thing is that you don't necessarily have to start from scratch, and indeed there are many benefits to looking to leverage your existing GDPR governance framework for AI compliance. So, there is the opportunity to build atop of what you already have from a privacy governance perspective. It's also important, however, that, as well as building out your privacy tools to cover the broader requirements of legislation like the EU AI Act, you're also ensuring that your tools for GDPR compliance take account of the specific issues that arise in an AI context, so that your DPIA in particular looks at the specific challenges that arise in relation to accuracy, honoring data subject rights, ensuring fairness and non-discrimination, etc. I think the very first step, however, is to understand what is happening within your organization. So what AI systems and tools are being used, so that you can really understand to what extent you need to consider risk. And to that end, I think it's worth having a look at this 6-point plan. So many of you will be familiar with data mapping and the need to understand the data flows within your organization so that you can then understand risk. The same principles apply in relation to AI systems. It's about understanding what you have, what your organization is planning to implement or to develop. So mapping the AI systems that have been developed, deployed, or planned, and determining the applicability of the EU AI Act and indeed other AI regulations, and indeed assessing what you have in place or what is planned to be put in place against any sort of ethical principles that your organization is seeking to adopt. It's key also to understand the organization's role. So is it a provider, a deployer, an importer, a distributor? So thinking back to that taxonomy of actors under the AI Act. So again, understanding that role and also how those roles relate to your GDPR roles. Are you acting as a controller, a processor, etc.? And how does that impact, for example, your data protection impact assessment? Thirdly, setting out some kind of risk classification. So understanding whether, for example, your AI system is outright prohibited. Obviously, you won't, you shouldn't be going ahead with it if that's the case. But whether it otherwise might fall within a high risk category, or indeed it is more of a limited risk, or falls within a general purpose AI model, or a general purpose AI model having systemic risk. So depending on the classification, of course, that will determine what your relevant compliance obligations look like. So I think there's scope there for developing various templates, AI questionnaires that look at whether your AI system falls within the definition of AI system within the EU AI Act in the first place, and to the extent it does, what your role is and what the relevant risk categorization of that system is and what that means in practice from a compliance perspective. Then number 4, looking at what risk assessments you should be carrying out, whether that's a fundamental rights impact assessment as a deployer or a data protection impact assessment if there's high risk involved in data processing. And then looking, part 5 is undertaking your assessments and identifying what risk mitigation measures you need to put in place. And there again, looking to leverage as far as possible your compliance efforts that are already in place from a privacy governance perspective. And then ongoing monitoring is obviously key. And we've seen this already in an accountability context under the GDPR, that it's not about doing a one-off DPIA or one-off LIA. It's about ensuring ongoing monitoring of the risk and ensuring that the risk is mitigated on an ongoing basis. So these are just some of the action points to have in mind, some of the things to start thinking about. Key to all of that is to really understanding what is happening from an AI perspective within your organization. So before I deal with some of the questions that have been raised, just to mention that there are some resources set out in the slide. We have a regulatory AI guidebook. There's a link to that on the slide. There's a data and privacy webpage with further information about our webinars. You can sign up to our blog. You can subscribe to our privacy YouTube channel. And indeed, these webinar series will be included on that. And so there's a link again in the slides for you to subscribe to that YouTube channel. So I think we have about 6 minutes left, so probably time for one or possibly two questions. The first question actually relates to the actual EU AI Act and when we think that it might be finally published within the official journal. And my understanding is, and based on the information that I've seen, is that that's due to happen in the second half of July. And then, of course, the EU AI Act will come into effect then 20 days after publication in the official journal. A question, I think possibly for Nuria. So if my company is not subject to the EU AI Act in a given context, are the relevant risk levels relevant to me? What should I be taking into account? I'll hand over to you, Nuria, to deal with that one.
Thank you, Leonie. It's a good question, actually, because obviously I'm sure there are many of our listeners may be global organizations that are just starting to look at whether they are caught or not under the AI Act. And what I would say is that I would suggest not to ignore the risk levels in the EU AI Act, because what I think has come across from our webinar and going back to what you were saying, Leonie, earlier, the EU EU AI regulation and is seeking to protect certain fundamental rights and values of our society. And these not only underpin European legislation, but they also underpin other or will underpin other EU AI legislation that will be in place in the future, but indeed also other international AI standards like the OECD standard. And these, in turn, these standards may underpin your own AI governance framework. So even if you're not caught by the Act, it's quite likely that under your own framework, certain activities which are not considered ethical and are considered prohibited under the EU AI Act would also be considered as not ethical and under your own framework, which may be based on other AI guidance that is in place at the moment. So I would definitely say, obviously, if you're not caught, you won't be required to meet all of the specific requirements under the Act. But I would say that do not ignore the risk classification in the EU AI Act, and actually it may act as guidance as to your own risk classification system within your own AI governance framework.
Great, thank you very much. Okay, and another question here, a really interesting one. How do you think the DSA risk assessments for VLOPs will fit in with all of these assessments? Yeah, also a really good question, because of course the DSA adopted back in 2022, now fully applicable since last February, that obligates VLOPs to assess and mitigate systemic risks. So there, we have the concept of a systemic risk also within the AI Act when we talk about general purpose AI models having systemic risk. Now, even though the concept of systemic risk across the DSA and AI are not identical, it will inevitably have many similarities. So I think, again, you'd be looking to leverage your efforts across both types of assessment in that regard. And I think there are some specific references to the DSA within the AI Act, so it's worth exploring those and to what extent you can leverage assessments across those two pieces of legislation. But, again, as with the GDPR, I would be looking to build atop what you already have and leverage the commonalities across these different pieces of legislation to make sure that, you're not duplicating your efforts. And I think that's probably all that we have time for. We've got 1 minute to time. So I will just thank everybody very much for your attention. There was a question as to whether the slides will be available, and they will be followed up. They will be sent out to everyone who's registered. To the extent that we haven't addressed your questions, we will follow those up. And thank you again very much for your attention. It's been our pleasure to deliver this webinar. Thank you very much.